This week on Inside Olympia, Chief Justice Debra Stevens on the state of the judiciary. What challenges do Washington courts face? How are judges dealing with increasing threats? And what are ways the courts are working to increase access to justice? That and more when we sit down with the Chief Justice.
From the TVW studio, it's Inside Olympia with host Austin Jenkins.
Welcome to Inside Olympia. Washington's court system faces a series of challenges. It also faces more scrutiny and even threats in these polarized times. So what is the state of the judiciary in 2026? What are the watch areas and what are the bright spots? Plus, there is suddenly a lot of turnover on the Washington State Supreme Court. What's driving that and what are the implications? Joining me now and for the full hour this week is the Supreme Court's Chief Justice, Debra Stevens. Welcome back to the program. Nice to see you.
Thank you, Austin.
It's been about a year since we last spoke. Lots happened since then. Just briefly, because it was a topic we discussed last time, how did the courts fare in this two-year budget? Understanding that it's an ongoing challenge to balance the budget, but what happened in the last session when it came to funding the third branch of government?
Well, we recognize this is a very challenging time for state government, for county governments, for city governments, with revenue shortfalls. So I think overall, this is, of course, a short session, so any carryover items are being considered. Last year, we were able to achieve some very important funding for interpreter services, where we can have state funding that helps support that across the state, for some initiatives around our therapeutic courts, self-help centers, because we recognize so many people who use the courts are unrepresented. But the overall funding picture remains a priority for me and for the entire branch, that we're still a tiny fraction of the near general fund budget, and we're running an entire branch of government that is so critical to people's ability to, meaningfully belong in society, from criminal justice needs to family support to drug courts and juvenile services. So we're still going to be pushing on that. I will say we didn't gain ground. We still have a long way to go on some essential services, and we're going to keep moving forward and making our case for why sustainable funding of the judiciary is really the heart of a healthy, strong democracy.
One of the reasons we wanted to talk with you is because each year the Chief Justice issues a state of the judiciary. In the odd years, it's an actual speech to the joint session of the legislature. In the even years, it's a written document. So we'll talk about some of the priorities and issues that were raised in the most recent, the 2026 State of the Judiciary. I'm struck, though, by the fact that there has been sort of some timely news topics that impact the Supreme Court. I want to begin with public defense. Again, last time we spoke, there was this outstanding question of how the Supreme Court would, I guess, decide, not formally rule, but decide on recommendations from the Bar Association or from the public defense system about reducing caseloads. And ultimately, the decision was made by the court to adopt these recommended standards. Pretty dramatic decreases in the felony caseloads and misdemeanor caseloads that public defenders in the state should be carrying. There's now pushback. We're hearing from some legislators saying that, including a former public defender, Senator Jesse Solomon, who said, cutting caseloads by 300% seems really extreme as a fix. And Lauren Davis saying, you don't solve the problem or a lack of attorneys by tripling the problem. So they're now looking at, are they going to have to fund this? What's the implication going to be? Can you give us some context and perspective for what the court was thinking here?
Oh, absolutely. First, I think part of the context really has to go back to how did indigent criminal defense arise? After the Gideon decision, courts have always had a role in ensuring that people who have a constitutional right to counsel and the effective assistance of counsel be provided that. So, back in the day, before my time, judges on the bench would find someone who was entitled to representation, and they'd look around the courtroom and, tap someone to take on that representation. Clearly, we've come a long way since then as state support and county support for assigned counsel. Sometimes it's called the Department of Assigned Counsel or Public Defense Offices has grown. But the court has had a role in ensuring that I should talk about the Bar Association, because well before court rules became a feature of looking at standards for indigent defense, bar associations adopted standards. So going back to the 80s, the Washington State Bar Association has had a fairly detailed set of standards. Yeah. In 2012, the Washington Supreme Court first adopted case standards in court rule as part of the professional responsibility of attorneys. And so the rules recognize we do not regulate county budgets, we do not regulate office management, but we do have a role in ensuring the professional responsibility of attorneys. And so looking at indigent defense standards is part of that. What the court has recently adopted is an update to the indigent defense standards. It may be a misnomer to say the court just adopted the rule that was proposed. That is not at all what occurred. It was a very detailed process, a lot of opportunity for public input, 2 public hearings, months of deliberation where the court took it piece by piece. There was a national study of public defense, the RAND study. There are local studies and surveys around specific areas of defense. And the court had to adopt standards that looked at the increasing complexity of certain cases and just based on what the standards showed for workload. So yes, it's a reduction in the case numbers, felony, misdemeanor, family defense, appellate defense, and specific parameters around each of those.
So when this rule was being decided on, how much, you're obviously thinking about what can a public defender reasonably handle in terms of a caseload, and what's, if it's a mix of felony and misdemeanor cases, what does that look like? But are you thinking about the implication if the new court rule is a dramatic reduction in caseloads? Because that obviously then creates this pressure. Either it means hire a bunch more public defenders or file fewer cases. Mm-hmm.
Absolutely. The court is aware that any set of standards that reduces a maximum caseload as a matter of professional responsibility is going to require some systemic change. I mean, that was the case in 2012. And I think some of what the court worked through and observed and learned from was that it's not that we just snap our fingers, obviously, and change occurs. It took a long time for that implementation. But we can also be proud as a state of the progress that was made even under the 2012 standards. And so in adopting the new standards, the court recognized that entities that fund public defense need time to plan. Though the rule doesn't directly regulate that, it sets a professional responsibility cap. And so in the implementing order, the court made it clear that there had to be steady progress, toward meeting the minimum standard, but that there has to be time for, budget development. There has to be time for changes in policy that may be made around how offices are organized or, criminal justice systems are organized. And of course, there's a lot of work being done, not directly by the court, but to build the pipeline of encouraging new attorneys to go into indigent defense.
And there is this, I guess, sort of 10-year phase-in, and yet there does seem to be sort of this, at least, moment of pushback that's occurring. And I should note that in Washington, it's the cities and the counties that are paying for the bulk of indigent defense.
It is. Mm-hmm.
The state pays a very small percentage, single digits, I believe. Some states, I think it's more of a 50-50 proposition. But do you have a particular message to state legislators, especially, in a time of tight budgets, about their responsibility to provide the funding, maybe to step into the breach in order to achieve these new standards? And I want to just go back to the numbers. 47 felony cases max, down from 150 previously. 120 misdemeanor cases, down from what was a case max of 400. So somebody said 300%. It's a big change.
It is a big change, and it's also, I think it's important to recognize that it's also data-driven about what is happening with cases. I think the message that I would share is a recognition that at the heart of all of this, and the reason the court gets involved with indigent defense, is the constitutional right to effective representation in criminal matters and certain other matters. And, you know, we have seen that we run our courts through a non-unified system, so that's been true from inception. So we have county-level funding covers really most of the costs of the court system across Washington. And then in public defense, of course, it's a county or a city obligation if they have a city department. And the court isn't wanting to weigh in on how that funding mechanism is going to be addressed. But I think it's part of a broader conversation around, you know, what do we want our criminal justice system to look like? And I don't think anyone in Washington wants a criminal justice system that is not effectively, you know, allowing for the advocacy that needs to happen in that real crucible of decision-making around something as important as a criminal matter. And, you know, that's really what the focus of the standards has been from inception, you know, because I do think it reflects more broadly on, you know, what we value in our criminal justice system.
Okay. Do you want to acknowledge that Seattle Times reported on this topic recently? Shauna Sowersby, those quotes from the lawmakers were from her story. Let me move to something else that's very much in the news, and that is the sudden, seems like, exodus from the Supreme Court. There's 9 members, and I think by my math, 1, 2, 3, 4 are suddenly or are now leaving. Justice Mary Yu, who was on the program not too long ago, left before the end of her term. She's since been replaced by an appointee. Justice Barbara Madsen recently announced her intention to step down before her term is up. Justice Raquel Montoya Lewis has said she will finish her term but not run for re-election. And then Justice Johnson is, I guess, aged out. You have to retire at 75. Mm-hmm. So I think you've told me that this is a generational change that we haven't seen since the 90s. So why don't we just start with speaking to the significance and sort of this moment, because it does seem, and certainly in my time covering Olympia, I haven't seen this many justices leave in one time.
Well, in my time on the court, we haven't had a period of turnover because we've had the benefit of long-serving justices on our court. In fact, if you take the collective experience on the bench of Justice Johnson, elected to the Supreme Court in 1990 at the age of 39, Justice Madsen, elected in 1992 at the age of 40, Justice Yu served for over 14 years on the Superior Court before being elected to the Washington Supreme Court in 2014. Those 3 individuals have a century of judicial experience among them. So we've had this incredible experience. We've also had some, you know, members of the court who, well, we've just benefited from that long experience. So when I became chief, you know, I looked at the bench and realized I'm gaining in seniority. In fact, when we start the January term with the new justices, I'll be the senior member of the court.
And you joined in 2014?
No, I joined in 2008. Yeah, January of 2008. And until Justice Melody's recent appointment, I was still the second youngest member of the court. So we've had the benefit of long experience. Under a constitutional amendment that came in the 50s, we have a mandatory retirement age of 75. And so both Justice Johnson and Justice Madsen, well, Justice Johnson could not run for re-election this year because of that mandatory retirement age. And Justice Madsen could not run for re-election in just under 2 years when her term comes up. And
right, so Justice Johnson couldn't run this coming year, and then she had 2 more years. But
yeah, she could not run in 2028.
Right.
So it's a time, you know, I think when I talked about the 90s, talking with Justice Johnson and Madsen, you know, when they first came on the court, there was a similar wave. There were a lot of senior members of the court, and there was that wave. It also hasn't been unusual over the history of Washington that we have justices who serve for 1 term. and then do other things. Justice Talmadge did not serve. He went back into practice and did other things. And I think it's to be encouraged that we want people who have a broad interest in the justice system, and that someone chooses not to run for re-election, as in Justice Montoya Lewis's situation, is not a sense that there's a problem with the court. It's a sense that we've got people amazingly committed to making justice better in many, many walks. So it's hard. I have to say, though, as someone who's really been mentored by the senior justices, who's benefited from having Justice Yu's voice, Justice Montoya Lewis's voice, as well as Madsen and Johnson around the table, I'm going to really miss working with them. But it's also an exciting time because every new member of a court really changes the dynamic, and in a 2-year period, we'll have 5 new members.
5 new members. So just a couple of questions on this point. As the Chief Justice, what's the practical impact here on court operations, appellate workload, kind of getting the new justices up to speed so that they can take on cases, and also, like, what is your sense as Chief Justice in terms of, do you feel heightened responsibility to sort of stabilize things, let the public know what's going on here, that this isn't just a mass exodus because something's wrong with the court?
Absolutely, both of those things. I think one of the roles of the Chief Justice is to help really bring people together and use moments like this as an opportunity to come together and build a stronger team. And we're going to certainly be working with our colleagues who are leaving the court about, the passing forward of their knowledge and their experience, strengthening and working with our court staff to make sure that as we're onboarding new justices, we do that in a way that isn't ad hoc. So we're really going to be building that smooth transition and knowledge transfer. Because as you know, in addition to the work of deciding cases, we do a lot of administration of justice through our commissions and committees and making sure there's a smooth handoff.
Will it slow the court's ability to decide cases?
Absolutely not. No, I think that's one area in which the transition of justices doesn't result in that at all. Though there's certainly a time to, build an understanding of our processes, et cetera. The new justices who come on the Supreme Court hit the ground running in terms of their legal ability and what they contribute to the debates, and we're certainly seeing that with Justice Melody. So, deciding the cases, we have excellent support staff to keep that moving, and we've been, really on top of our game in terms of the timely deciding of cases. It's so much faster now than even when I first came on the court. The commitment to moving the cases through in a timely manner. I think the place where, the transition really opens up new opportunities is in, all the ways we administer justice in addition to deciding the cases and the smooth running of our boards and commissions.
The departures, of course, if you leave before your term's up, does give the governor a chance to appoint. That has caused some heartburn, especially among Republicans. In fact, State Representative Hunter Abel has introduced a bill that would require Senate confirmation for Supreme Court and Court of Appeals appointees. He says confirmation brings balance, accountability, and public trust back into the process. The governor, going back, to Inslee's 12 years, he appointed a number of members to the court. How would you address that concern, or, as I said, on the part of the Republicans, heartburn about, and it's Supreme Court justices, Court of Appeals, and even Superior Court judges, but leaving before their terms are up and then giving the incumbent Democratic governor an appointment? And then the argument is it's much easier for those incumbents are in a good position to then get elected. They have an advantage, is the view.
Right. Well, I have several thoughts about this because, we, even at the time of statehood, of the framing of the Constitution, it was hotly debated about the method of selecting judges, and our state is firmly committed to open, nonpartisan elections. At the Supreme Court, justices run every 6 years, so that's a pretty long term. That's also true at the Court of Appeals. Those are the state-level judges. And then in the trial courts, they run every 4 years. So we do see more turnover without, someone serving out a term. I zoom out on this topic, and the first thing I'll say is there is absolutely confirmation of any gubernatorial appointee, because they have to stand for immediate election, and then they have to run for election again in the year that the seat is up. So for those being appointed this year, as an example, both of those seats are up for re-election in 2028, and there'll be another election.
Just to be clear, that they'll be on the ballot this year and then on the ballot again in 2028.
Yes. So I always said I was initially appointed in 2008.
By Gregoire.
Yes. And I had been appointed initially to the Court of Appeals as well. And as I joked with my husband, that gave me exactly one vote, which was the governor's, and you have to earn the rest. So I do think that process is not... it's not meaningless. I mean, I really push back on anyone who says there's such an advantage to incumbency, because when it's a gubernatorial appointment, many of those races are challenged. And of course, we've seen instances in recent years. You mentioned Governor Inslee, and several appointees, were challenged. And I served with one member of the Supreme Court who ran again after having been appointed to the Court of Appeals and then defeated in the first election. Just before my time, a justice appointed to the Supreme Court was defeated. I think what I am seeing this year that doesn't really open up that broader conversation, a perennial conversation about the method of selection. Yeah. What I don't see happening this year is that sense of the whole court is turning over and the people don't have a say. Because Justice Johnson, as he's aging out, his seat is an open election, and people are already filing to run for that seat. Justice Montoya Lewis announced early that she's not running for re-election, and people are already filing for that seat. So, I think it's just one of those moments in our history when we're having that historic change on the court that we haven't seen since the 90s.
Do you think, I guess, one of the additional kind of criticisms I've heard is that this is becoming, the appointments become are supposed to be the backstop, if somebody has to leave because of health reasons or whatever. As you said, these 6-year terms, a lot can change. But that the sense is that, at least among critics here, that this has become the norm. There's this group, the Full Court Press, that Rob McKenna and Michael Baumgartner are part of. They did some polling. They showed 72% of voters say judges should be expected to fulfill their terms, so that voters, not governors, are picking. I mean, are we getting, do you think, too comfortable with this?
I think these are the same arguments that I've heard since I became a lawyer, and certainly since I became a judge. I mean, there was criticism when Chief Justice Gary Alexander ran that he couldn't finish his term, though he could serve 5 of those 6 years. I guess
because of his mandatory
because of his age,
yeah,
right? Because of age, and I think part of what the people balance when they look at who to vote for in an election is that the benefit of that long experience as well. Okay. But I don't know that. I guess I don't find that any of those comments new or new to this year in this particular cycle. I've heard those my whole career.
You do have a new colleague, Justice Colleen Melody, who Governor Ferguson appointed recently to replace Justice Yu. She hails from Spokane, as you do. And she also headed the Civil Rights Division at the AG's office. I'm curious if you guys knew each other before she joined the court, and sort of what a comment or two about your newest member.
Yeah. Well, we did not know each other from Spokane. I think she
not
was...
that everybody in Spokane knows everybody.
Right, exactly. And I think she was born the year I graduated high school. She joined the court in January, and so has been sitting on the winter term and, really has hit the ground running. She was a very experienced litigator, just incredibly brilliant, and works harder than... I've never seen anyone who works harder, and I work with a lot of hardworking people, so she's just been an amazing colleague. I think, her coming from Spokane it means a lot to me. I'm actually the first woman ever from Eastern Washington to serve on the Supreme Court. And, for many years, a criticism about the court was that it was very I-5 corridor, really just King and Pierce County focused. And I think we've seen a lot more diversity on the court. And I will say, across the gamut, one thing that I just want to pause and observe about appointments, because there's a lot of research on this too. If you look at measures of diversity, women, ethnic minorities, geographical diversity on the bench, statewide, in our state and others, it comes through initial appointment more often than not.
Okay. I also want to note, and this was in your State of the Judiciary, the number of former Supreme Court justices who passed away recently. Yeah. I want to note former Justice Susan Owens, who died shortly after she retired in late 2024. That was very sad. Justice Carolyn Dimmick, who was the first woman to serve on the court. That was in 1981. Dixie Lee Ray appointed her, I believe. Mm-hmm. Also retired Chief Justice Richard Guy, Justice Charles Wiggins. I'm not going to ask you to speak to each of them, but can you just reflect a little bit on, not only are we seeing a lot of people leave the court, but a lot of former justices passing away recently?
Oh, yeah. And I do want to reflect just a moment on each of them, because I had a very personal connection with each of them. Susan Owens, we may have talked about because of her retirement last year, and she was a district court judge, a tribal court judge, and then a long-serving Supreme Court justice, over 40 years of judicial experience. She was also just a great mentor to me and a great friend, and her passing, she was experiencing health issues. She aged out, but her passing really hit all of us hard. And she died early in 2025.
Right, exactly.
Yeah. Justice Carolyn Dimmick was a force of nature. She was one of the first women to pass the bar in 1953. Experienced, incredible marginalization during her path forward, but it never slowed her down. She didn't serve on the Washington Supreme Court all that long, only because she was then appointed to the federal court, where she continued to hear cases well into her 80s.
Oh, my.
And even, I think I last saw her around her 90th birthday, or maybe 91st, and she was still sharp as they come. She died at the age of 96 and was the first woman ever, of course, to serve on our court. A great mentor to every woman I know who had the chance. She was just such an inspiration and really believed in giving a hand up to others. Justice Richard Guy, who was a Chief Justice of the court, was the last justice from Spokane. So I did know him in Spokane, and he supported me and was a great mentor, and also, lived a long, rich life. Justice Charlie Wiggins, we had cases together. We were both, did a lot of appellate work. He was one of my great heroes, and I learned so much working on appeals when I was a young lawyer working with him. And it was such a thrill for me to be able to serve on the bench with him. And sadly, he died far too young for, he was, they were all just amazing folks. So yeah, we're feeling that loss. And I will point out that we had a beautiful memorial for Justice Owens last May, and this May we will have a joint court session honoring Justice Dimmick, Justice Guy, and Justice Wiggins.
Okay. Great. Well, let's take a quick break. When we come back, we will continue our interview on the state of the judiciary with the Chief Justice. Debra Stevens, back after this.
I hope that folks understand that we're deeply rooted in our communities. We care deeply for the communities that we work for, and we want to see the legal system work the way that it's supposed to, and the way that the Constitution expects it to.
All this is going to negatively impact public safety. There will be breakdowns in the system, and I think when we talk to the public about it, it's going to scare them.
Folks have had enough. They can't afford the impacts of these tariffs. Talk to folks who run car dealerships who are saying that they're going to prioritize a lot more just on servicing cars and less on selling cars. Talk to the multiple generation shellfish farmers on the peninsula. They're talking about closing businesses. Talk to the agricultural community here that is being impacted. Talk to the aerospace community. And more importantly, talk to the average consumer who doesn't want to be paying a significant amount more for groceries, food products, any type of new purchase that they make.
Stolen vehicles are a problem. We need a solution.
pursuits are not the solution to that.
Washington State is not missing high-speed police pursuits. Washington State is missing the possibility of a high-speed pursuit.
Welcome back to Inside Olympia. Joining me once again is Chief Justice Debra Stevens of the Washington State Supreme Court. I want to transition to a topic that's been in the news as well lately, and that is that judges here in Washington State and across the country are increasingly facing threats. There was a recent panel involving federal judges from around the country, including from our state, who talked about what they've been experiencing, especially often after ruling against the current administration. Victims of swatting incidents. Of course, we had the son of a New Jersey federal judge killed by an attacker who came to the family's home. Unsolicited pizzas have been sent to judges' homes, which might sound like a prank, but it's a way of letting judges and their family members know that people know where they live. What kinds of conversations are being had in the courts here about threats, security, the kind of current state of kind of polarization?
Yeah, this is definitely a topic of conversation, both here and, as you note, across the country. I'm also, as Chief Justice, I'm a member of the Conference of Chief Justices, and it's a conversation we're having at that level and advancing, advocating for some congressional legislation to really look at supporting state courts.
Would that be
as we
funding
work
for
to-
security
Yes,
apparatus or
yes.
something else?
Yeah, right, funding for helping build out security because, state courts, I have to say that over the, history of how courts evolve as public institutions, security hasn't been top of mind. When I first joined the Supreme Court, we're on the Capitol campus. It was just a wide open building. And, you could just open a door and walk in an office, and there was no perimeter screening. And I think, unfortunately, that's the result of some tragedies that have happened in other states have really led courts to look differently at the need to make sure not just the judges but all of our court staff are safe when they're at work and in their lives. I do think there's no denying that the increased politicization of the work courts do, and that's not just in this immediate moment, but that's been building over many years. So that increased politicization and then just the increased polarization perhaps of all public discourse has led to many elected officials and judges, or public officials, judges among them, experiencing some of the incidents that you've highlighted.
Is there funding or an apparatus in place now to increase security, to provide security audits, to install cameras even at homes and stuff, that kind of thing?
Nowhere near, no. One of the pieces of the federal legislation ask is to try to get for state judges some of that funding for their own personal security, including away from the courthouse that federal judges have to help support that. But at the state level, no, security is not adequately funded for courts or for many other public institutions. And we have some bills that we ran last year and again this year where we're really looking at trying to build out some ability to keep our courts and our judges safer.
I would imagine that funding becomes a bit of a barrier when the budget's.
Yes, and so one of the
hard time.
things we're asking for that helps address the need without additional cost to the state is to allow us to use our own security officers, many of whom have a law enforcement background, to do at least threat assessments. We have that at the Supreme Court. We really need to expand that. Through our administrative office of the courts, we have a security officer who helps consult with the trial courts and giving that office and that person, right now it's one person, the ability to do that initial threat assessment. I think it assists law enforcement. They're overburdened.
Because right now they don't have the actual authority to do that?
Right.
No.
Right.
And so you need a law to do that.
Right, well, yes, we need a change in statute to allow them to access the non-conviction data and do a thorough
Because right
threat
now that would fall
assessment.
to local law enforcement that may
Right.
not have the resources.
That absolutely. We know how they're under, they need more resources as well.
The sort of flip side of this equation is how do you build back some trust and confidence in the courts and public understanding if the tide is such that people are looking maybe increasingly at the courts as not trustworthy and not worthy of confidence.
And that's really an area of focus among judges, courts, and the Bar Association, which last year launched what they're calling a Rule of Law Ambassadors program to really help lawyers be better at telling the story of the justice system and what courts do and the importance of adherence to the rule of law. I do have to say, though, that it's complicated in the way people get their information. And you and I have talked about this. We both participated on panels about, information bubbles, and it's challenging for courts to be able to tell the story of what they're doing in a narrative that doesn't get politicized, because people increasingly get their news from sources that come at it from a different political angle. But we are trying to support courts, including through our Bench Bar Press Committee, in developing ways to make to increase public understanding of what they do, sort of civic engagement opportunities, and do that within their existing resources. Very few courts have a public information office. And so it's really, I think sometimes the best ambassador for the justice system is the judge who visits a school or a service club or a senior center and just talks about what's going on in their world and how they do their job.
Just lastly on this, what is your sense of the crisis level or the threat level when you think about your career? And we're talking about judicial safety and security and trust and confidence in the judiciary. Where would you place or peg that right now?
From my arc, and again, I started in the judiciary in 2007 as a Court of Appeals judge, and then 2008 came on the Supreme Court. I think it's continued to get worse. I think some of it is the increased. It's definitely increased politicization of what courts do. But I think also, there's more polarization, and all features of government are more under criticism. And so, a lot of the polling shows that courts are still among the branches of government. The judiciary is still the most trusted of the branches of government, but the trust levels generally in government are going down. And I think, it's part of our job. I don't know where we would be as a democracy without strong institutions. And so, I think courts need to be open about the importance of reform and of addressing real needs in society and being fair and impartial. That's meaningful conversation. But, I think there's no place in public discourse for simply trying, for violent attacks on judges because of their decisions. And we do have judges here that, I don't know if you've had them on the program or you were just talking about the panels, but who have received, these pizza deliveries, and the name on the delivery is the son of the federal judge who was murdered. So it's a pretty direct message. Yes, it's pretty jarring, and there's just no place in public discourse for that kind of those kind of attacks.
Let's transition to some of the topics that you raised in the state of the judiciary. And one of the issues, in fact, I think right at the beginning that you highlighted was disability access. There was a first of its kind Disability Justice Symposium and report that came out. Justice Helen Whitener co-chairs that task force, said that the findings were pretty dire. She said, this work has brought validation to voices, and again, we're talking about people with disabilities, that are too often overlooked. People with disabilities who have waited far too long for the courts to hear them, see them, and act. These findings we share are not just observations, they are indictments of a system that must do better, an invitation to transform that system together. I'm curious kind of what your response is to this finding, and then what the courts can do, again, in constrained financial times. And you often talk about access to justice, right? To make the courts, to make the legal system more available and equitable to people who, and that could be staff, that can be the people who are trying to access the courthouse, any number of people.
Yeah, so as you mentioned, last September, we had the first in the nation disability justice symposium.
I didn't realize, I thought it was first in the state, first in the nation, okay.
And I do want to be clear that the real focus of the Disability Justice Task Force was not to look at, like, Americans with Disabilities Act compliance. And, I think our courts...
Which would be sort of basic accessibility. Can you get in? Is there an elevator? Can you get to the courtroom? That kind of thing.
And courts have put resources, time, energy really into improving those situations. And as you note, it dovetails, especially the physical barriers and the barriers that require staffing and new program development, dovetails with budget concerns. Some of our courthouses are the most beautiful historic buildings in Washington, and they are really inaccessible.
Yeah, in fact, TVW has gone around and taken lots of video of them.
Yes,
Pictures
and
stuff.
our
They
Temple
are
of
beautiful.
Justice, the beautiful Supreme Court building, has real accessibility challenges. And, so the focus of the Disability Justice Task Force, and for me, a big aha moment was that we have to look at everything we do and the access to justice through a lens of disability justice, and just not look at doing things in the way we've always done them, plus adding an accommodation, but look at, are there different ways we can imagine how we frame our workplace, our work, our meetings, any number of things, in a way that creates more belonging and removes barriers by just pivoting to a different way of doing business. And I think for a lot of folks, that was a very eye-opening way to look at disability justice and access to justice beyond just a compliance point.
Is there an example that comes to mind?
Oh, certainly. Just the way we set up meetings or Zoom. Let's say, for example, when you're having a remote meeting, and you may have people who are visually impaired or hearing impaired. Are you making sure that each piece of information that's being delivered is available to everybody there? You don't want to have messages that simply pop up on the screen and aren't spoken out loud.
They can't see,
The
for
creation
instance,
of slides. Certain people with sensory challenges, and disabilities need to see information displayed in a different way. So learning more about the access challenges, I think, can help us all, across our lives, not simply in our workplaces, create a greater sense of belonging for everybody who's participating.
Among the recommendations were that the Supreme Court should consider developing a recurrent implicit bias training for judges and judicial officers on topics of accessibility. Another proposal was to establish a permanent commission on disability justice to guide the long-term implementation of recommendations. What is the status of those recommendations? Where would funding come from? Where do you go from here?
Right. So when the report was released and it was shared at the time of the symposium, there was not an action plan created out of that. There were identified barriers, there were identified recommendations, and I think where we are now is sharing that broadly across the branch. And we want to hear from our partners, from the trial court associations, working with what we have at the Administrative Office of the Courts, looking at our partners in other branches of government. And I think there's a lot of work ahead. It's not just we know what we want to do and now let's fund it. It's that this is a real conversation starter around a broader disability justice lens. And, before this report and this symposium, I think we weren't looking at it, from that perspective. Again, there's compliance issues, and I really want to underscore how hard our courts continue to work on making, courts accessible, meeting those needs. At the state level, the Administrative Office of the Courts has been able to share resources, technical assistance, and some funding to help county courts. I visited a court in Yakima recently that developed a fully accessible courtroom. So, that was very exciting, and they did that in part with support from the state funding from the Administrative Office of the Courts.
Another topic in this state of the judiciary is justice for Indigenous people. In 2024, the affiliated tribes of the Northwest Indians issued a resolution calling on the state Supreme Court to issue a proclamation regarding legal and judicial systems and the need to rectify areas of unequal treatment towards Indigenous people in the state's legal system. Subsequently, the Minority and Justice Commission, which is part of the courts, held a symposium last year acknowledging harm. I'm curious if, kind of again, same question, next steps, where do you go from here? Now that there's been sort of this maybe call and response, right? Here's an issue that needs to be addressed. Okay, let's sit down and start to discuss it, but where do you see it going?
Yeah, can I say I really see it not as starting with that particular historic moment, but I think an increasing awareness of the importance of creating of the justice system hearing from Indigenous communities. We have been so fortunate to have Justice Montoya Lewis on the court, an Indigenous person affiliated with two different tribes, but also someone who's worked in tribal courts, has the lived experience, has really brought to everything that we deliberate on in the court a sense of the I think you've heard the phrase probably of things that have been hiding in plain sight. You know, sometimes you don't see what you don't see when you don't have the right voices in the conversation. And so I think it's been an ongoing recognition that just needs to keep growing. And I think sometimes the best path forward is for people like me to just receive information and hear the broader concerns, because it's not as if there are that there's one solution or one approach to a complex of problems. It's really part of a broader and I'm happy to say increasing awareness across our government systems that we haven't had all the voices at the table. The right people have not been in the room when we've made a lot of decisions. And so I think keeping steady momentum forward to rectify that problem includes really advancing justice for Indigenous communities.
Something else that happened last year, and I just mentioned the Minority and Justice Commission, it also published a comprehensive report on youth diversion. Diversion refers to the idea of moving somebody away from sort of traditional prosecution into some alternative that keeps them out of the courts. Apparently the rate of diversion for the last 30 years has been pretty much flat across the country, even though when young people in particular go through this, it shows often improved outcomes and it reduces racial disparities. So, and we could have a whole conversation about juvenile justice in this state, and there's a lot of frustration on the part of some that we don't have a handle on it. But for purposes of this question, what efforts are underway to increase diversion opportunities in Washington state in light of this report?
Yeah, I think one of the things we want to highlight in the report is how much work is being done in the juvenile justice space. I had an opportunity recently to meet with the Washington Association of Juvenile Court Administrators and just get an update of work that's been done under some long-standing legislative programs, as well as some newer initiatives, what they're doing creatively with their local resources. And one thing that I consistently hear is that in order for diversion programs or other alternatives to incarceration, even to prosecution, we sometimes we're talking pre-charge diversion, that in order for that to happen, you have to have good service providers, community providers. So it's to some extent there's a funding gap, but there's also a need to creatively grow the services that we have. And one of the challenges that I talk about frequently for the branch is that over decades, the justice system has been asked to be a provider of a lot of social programs, through drug courts, through juvenile courts, through criminal justice, et cetera. And growing those and developing the real community resources can't be done by the courts alone. It really takes partnership, and not every community is the same. And these things have to be local. It's so. I think in part what we're really working on is juvenile justice court reform, juvenile court reform, but also looking at growing opportunities for alternatives, and you need service provider, service partners across communities to do that.
I do want to note that you also, in your State of the Judiciary, talked about challenges around self-represented litigants in a lot of civil cases.
Right.
Or civil situations. People are representing themselves, trying to get more resources to people who have to navigate the courts or civil legal situations on their own.
Mm-hmm.
Also the need, there's a shortage of legal language interpreters in court, which is an ongoing issue. Some pretty interesting kind of pilot projects in certain areas of the state to try to address that, especially when you've got Indigenous languages that are
Right.
not maybe widely spoken in a sub-community in a particular community, but not maybe widely spoken everywhere. Of course, the ongoing kind of fallout from the Blake decision, which overturned the Supreme Court overturned the state's simple possession law and trying to reach those people. Why don't we just briefly update kind of where that stands, because it's reaching out and finding those individuals to allow them to have their convictions vacated and then potentially to get reimbursement, I guess, for civil, for fines that were paid.
Fines, not civil. We're talking
Right,
about legal
criminal,
financial
like
obligations
also, yeah.
that were attendant.
So the numbers I have is there's a Blake Refund Bureau that has processed $6.6 million in fines to 6,000 individuals since 2023. There's still money available, but what efforts are kind of underway to reach more individuals, issue more refunds, that kind of thing?
Yeah, so on Blake specifically, after the Blake decision and the legislative funding, it became very apparent that a key to moving forward with this work and being able to refund the legal financial obligations that needed to be refunded under the constitutional, if you have an unconstitutional conviction, then you have the fines and fees that were attendant to that needed to be refunded. It's not a simple matter of putting a notice on the radio or in the paper or on your website. So really essential to getting that work done was support for the local courts and the creation of what was called the Blake Administrative Vacate Unit for certain class of cases to move those more quickly. It takes time to ramp all of that up. And in particular, what we found as a model that worked was providing assistance to local courts to be able to have these Blake vacate days or refund systems so that they could find their cases, get the notices out, and then have the judicial processing of those cases. Unfortunately, while there's still the ongoing funding, as there must be, because it's a constitutional obligation to refund the money, without the resources to support the courts in getting that done, a local
And doing
court
the outreach.
in doing the outreach and also putting together the list,
Yeah.
that ramp up time was necessary. So we're continuing to advocate that we need that ongoing funding. It's in the first year or two of something, it's difficult to really ramp up, but I feel like we're up and humming along now, but without that support, things are going to slow down. So I hope we're going to see a recognition, and we're going to be talking about this again next year, that if we don't have that ongoing support for the structure to make this happen, we're not going to get this done in a timely manner. And so if we really want to accelerate and accomplish that work and kind of close the books on Blake, we need to keep our foot on the gas to create those supports.
Okay. We are out of time. Just a last word as you think about the coming year, the changes on the court, the new faces, the mission going forward. Just briefly.
I think it's an exciting time. It's a time to celebrate the long careers and the historic careers of the justices who have served the court so well. And it's a time to recognize we're in that generational change. I'm excited and optimistic about the future, and I feel so blessed to be serving with such incredible people on the Supreme Court.
Chief Justice Debra Stevens, thanks for coming in. Appreciate
Thank
it.
you,
Good to talk
Austin.
to you again. Thank you for watching Inside Olympia. We will see you again next week.